If you know one thing about money and politics, it's probably this. The landmark Citizens United Supreme Court decision in 2010 declared that political spending is protected speech, and that restricting the independent spending of corporations, unions, and nonprofit groups violates the First Amendment. It was a striking 5-4 decision, and it is still a flashpoint in politics today. Efforts to restrict money flowing into super PACs, which can spend unlimited amounts on campaigns, keeps bumping up against the same issue. Under Citizens United, that is just plain unconstitutional. Well, not so fast. Maine voters in 2024 overwhelmingly passed a ballot measure limiting super PAC contributions to $5,000. Now that's what people could give to the PACs, not what the PACs could spend. But of course, the super PACs sued. And they won in the lower court. But maybe that was the plan. I'm Jennifer Smith, and this is the Codcast, CommonWealth Beacon's podcast about policy and civic life here in Massachusetts. Today, I'm joined by Harvard professor Larry Lessig, who is part of the coalition that brought the referendum to Maine voters after a similar measure never made it to ballot here in Massachusetts. Now the Maine case is, funnily enough, back in Mass. An appeal will be filed in October with the First Circuit Court of Appeals in Boston. Lessig and the Maine officials defending the measure think they have a chance, if the appeal eventually makes its way to the U.S. Supreme Court, of getting the overwhelmingly conservative court to crack down on this sort of political spending. Well, Professor Lessig, thank you so much for being here today.
Thanks for having me.
So we are talking on a Massachusetts policy podcast about a case that is happening because of Maine. Why are we talking about Maine today?
So Maine, in 2024, passed an initiative, question 1, that basically bans super PACs in Maine. And that initiative is designed to force the legal question, which the Supreme Court has never yet answered, which is whether its decision, Citizens United, means that someone has a constitutional right to contribute unlimited amounts of money to political action committees. That decision that they do was made by a lower federal court in the D.C. Circuit, and the Supreme Court has never had a chance to review that question. So now if the First Circuit Court of Appeals, which is where this issue will be first decided, if they rule in favor of the Maine initiative, then we will certainly be in the United States Supreme Court. And if we're in the Supreme Court, we'll give the court a chance to answer the question.
So getting into that question at its core here, there's a lot of discussion about kind of the place of super PACs or these political action committees and sort of their role and responsibility and interaction with political candidates and campaigns. So break this down on kind of a very layperson level here. What is the argument from Maine voters, and of course in this case, on what should and should not be limited?
So all that the Maine initiative does is limit the size of a contribution to a committee that is making independent expenditures. It's not trying to limit the amount of money the independent committee might expend. So what the Supreme Court has said, starting in 1976, is that you can't limit expenditures because of an independent variety. Like if you're independent of the campaign, you can't limit expenditures because there's no risk of what the court called quid pro quo corruption, this for that corruption. And the reason that kind of makes sense under that logic is that if the only basis for suppressing political speech is the risk of corruption, and some speech is, quote, independent, then, as the Supreme Court said in Citizens United, almost by definition, there's no risk of quid pro quo corruption. Or if there is a deal, a quid pro quo, then it's not independent. So that's the basis for the Supreme Court's repeated holding that you can't limit expenditures. But then when you shift to the question of contributions to the committee that either makes those expenditures or a committee that is supporting a candidate, the court has universally held that when you're talking about contributions where there is a risk of quid pro quo corruption, then you can limit the size of the contribution so as to reduce the risk that the contribution is part of some illegal quid pro quo. And so that's the principle that Maine is resting on when Maine defends its initiative now in the First Circuit Court of Appeals. And surprise, surprise, I'm actually optimistic, not just that the Court of Appeals will get it right, but that the United States Supreme Court will get it right as well.
So, of course, I have to put on my skeptic's hat here and note that one of the rulings by, or the kind of underpinnings of the lower court decision considering this Maine case, was that the question of how we define political speech and expenditures in this manner has been very consistently decided, not just from the Supreme Court, but in all of these lower courts below. And the judge in the lower court concluded that the core of it, in their view, was this sort of sufficiently removed question. If these super PACs are already considered enough removed from the candidate that they can expend independently, then why is the person contributing to these PACs not an extra sort of degree of removed, so distant as to make it very hard to figure out what that kind of corruption tie is? So why wouldn't that be part of a piece of this kind of extended universe of Citizens United rulings that would basically kick you out the door at the next circuit as well?
Yeah, so I had a similar experience when I read that part of the lower court's opinion with a colleague of mine who's also working in a similar space. And what she said to me is, when I read that, I thought, oh my gosh, did I miss that in Citizens United? Because that argument is completely new. Like, no court has ever advanced that argument. And indeed, every other circuit court to uphold the principle that you can't limit contributions to independent political action committees has done so under the assumption, expressly stated in all of these opinions, that such contributions cannot create the risk of quid pro quo corruption. This court, for the first time in federal court history, this court has said, oh yeah, there is a risk of quid pro quo corruption, but still, here's some brand new theory of the First Amendment that explains why even still you can't limit the size of those contributions. Now, I think the First Circuit's going to look at this and say, this is an extreme position. The Supreme Court has certainly never said that where there's a risk of quid pro quo corruption, the state or Congress is forbidden from limiting that risk by limiting the size of contributions. That's brand new. And this whole removed, one step further removed theory is kind of clever, but it's the sort of thing that when you think through it for 5 minutes, you realize it just makes no sense, right? So she said, the district court said, well, you know, if the expenditure is sufficiently removed from a direct contribution to a candidate so as not to be subject to limitations, then the contribution to the committee is even further removed and creates even less of a risk of corruption. Okay, look, right now, the most I can give a federal candidate is $3,300 in a federal election, $3,300. If a super PAC wants to contribute, or if somebody wants to contribute to a super PAC supporting that candidate, they can give that super PAC, like Elon Musk in the last election, $277 million. They can give them as much as they want. Now, the idea that the risk of corruption from a $3,300 contribution is greater than the risk of corruption from a $277 million contribution is just crazy talk. It's not any opinion that the Supreme Court has ever uttered, and we're pretty confident that once the judges look at it, they'll see this was just a court grabbing for the opportunity not to go against the grain, because it is true, all these other opinions 10 years ago have basically said that super PACs are constitutionally protected. And they are all wrong. And it's going to surprise the world. But I think the Supreme Court, I'm betting 7-2, but at least 5-4 is going to agree that they're all wrong.
So I think it might be helpful to take a little second for some 101 level. What are we talking about when we talk about corruption? What do we talk about when we're talking about regulating money in politics? On a very kind of human level, what's the fear here? If Elon Musk gives this many hundreds of millions of dollars to a super PAC, what is the concern that that does?
Yeah. And the reason people sometimes are skeptical that there's a real problem here is that they say, hey, there are Democratic super PACs and there are Republican super PACs. So what are you really worried about? What's the problem? Well, what we're worried about is that though there are Democratic super PACs and there are Republican super PACs, there's not working class super PACs versus rich person super PACs. Like, all these super PACs are basically funded by the super, super wealthy in America. Indeed, 75% of the money that was contributed to super PACs in the 2024 election came from people giving $1 million or more. Now, I don't know about you. I don't know anybody who's made a $1 million contribution to any political entity at all. So this is a very small group of people who have a very narrow sense of what sort of issues our government should address. And it turns out the issues they care about are not the issues that ordinary Americans care about. So, the most successful super PAC since 2010 and 2012, and I want to talk about the 2012 example, but the most successful super PAC since 2012 was the crypto super PAC in the 2024 election. Now, one could argue about whether the crypto policy under the Biden administration was the best policy or not. I'm a great admirer of Gary Gensler, the head of the SEC. The SEC is constrained in how they make policy. They basically make policy through litigation, not through rulemaking. So there's relatively little he could do except to go out and bring a bunch of cases to try to craft the law relating to crypto. So it might not be the best law, but it was not insane. The government now has embraced the dumbest crypto law you can embrace, because basically this super PAC went out and took out a bunch of members of Congress, elected another bunch of people in Congress, created the fear of God throughout Congress, that you can't go against the crypto industry, and then got a president who created his own meme coin and now has earned billions of dollars from his own crypto ventures, right? So they flipped policy, not in a way that ordinary Americans care about, not in a way that helps ordinary Americans. They just flipped policy because they could effectively buy Congress. And now we see that the AI industry has announced that they're going to create the same vehicle for the 2026 election and the 2028 election. And so now you think, geez, it would be great if we could have some sensible policy around AI. There are a lot of very smart people, mainly people inside of the AI industry, who are saying, this is a really terrifying technology and we need to make sure it's safe. And many don't think it can be safe. But the point is, at least we should have sensible regulation about it. But I can guarantee you, if the super PAC structure that we have today is around in 2028, we will elect a president and a Congress that will say, oh my gosh, no, we can't possibly touch AI because AI is the golden goose, blah, blah, blah. Not because it makes sense, not because it benefits ordinary Americans, but because it is what the super wealthy funding those super PACs want. So if you want policy that responds to what ordinary Americans care about, you've got to stop electing people with billionaires' money. If the billionaires are electing them, they're going to follow the billionaires. Remember, he who pays the piper calls the tune. And the billionaires are paying the piper right now. And what we've seen in the last 10 years is that they are calling the tune. That's why there's a problem here.
So the kind of down in the core of, I remember when I was, younger and hearing about the Citizens United decision in the first place, and the primary description that most people understand coming out of Citizens United is that it was the court declaring that spending money is political speech. It is protected in many ways. It is expression of your political preferences. So even more perhaps 101 here, isn't what you're describing people demonstrating a sort of political speech that the Supreme Court has said is allowed? They didn't say billionaires only get to express the same amount of speech as anybody else. They were saying you can use what you have and spend it as you like. That's political speech. So kind of square that for me.
Yeah, there's no doubt. I mean, there are some people who say that money is not speech. That's a very sexy thing to say. And I get it. I get why people say that. I actually think that's a mistake. Like if Congress could pass a law that says the most you can spend when you're running for Congress is $10,000. And, you say, well, what about, being, what would that do? What we know that would do is mean that nobody from Congress would ever be defeated by a challenger. And then you say, well, that's a bad thing. Shouldn't I be able to have a constitutional right to say I should be allowed to spend more? And if money is not speech, the answer is no, you don't have any right. Like the point is, it's just something to regulate. So I think it is true to say money is speech. But what the court has said consistently is, yeah, money is speech. And you can't limit speech unless there's a risk of quid pro quo corruption. So what Citizens United said was, there's no risk when you're talking about an expenditure, because the expenditure that is independent means, by definition, you've not struck a deal with the politician. If you did strike a deal with the politician, it's not independent, and therefore your expenditure becomes a contribution in violation of the limits on contributions. So that logic, I'm not attacking here. I'm not saying you might not like that logic. We might like a different First Amendment as it applies here. That's all fine. But that logic kind of makes sense. But the point is, applying that logic to contributions produces a different answer. And the best example to see that is my favorite senator, Robert Menendez from New Jersey. So like in 2015, Robert Menendez was indicted. He was indicted because the government alleged he had promised favors to a Florida businessman in exchange for the Florida businessman making a contribution to Menendez's Super PAC. So there it is, quid pro quo corruption, but a contribution to a Super PAC. The very thing that the DC Circuit, when it created Super PACs in a case called Speech Now, said could not happen, because they said there could be no risk of corruption with a contribution to a Super PAC. Well, there it was. It was a plain allegation of corruption with a contribution to a Super PAC. Indeed, Menendez's lawyers had the chutzpah to file a motion to dismiss the indictment, saying, the thing you've indicted us for, the DC Circuit says can't happen, so therefore we must be innocent. And of course, the judge kind of chuckled at that, but it showed the logical mistake at the core of that opinion. Now, I'm not the first person to see this mistake. Indeed, it took me a long time. I feel kind of stupid for how long it took me to see that mistake. But my colleague, Larry Tribe, and my former colleague, Al Schuler, and my friend Richard Painter, and my friend Norm Eisen wrote an article, I think it's 2015 or 2016, where they said, look, people are just misunderstanding what Citizens United means. Citizens United means expenditures can't be regulated. It doesn't mean contributions can't be regulated, because the same logic of Citizens United should say a contribution can create the risk of corruption, and every time you identify the risk of corruption, the Supreme Court has said, okay, the state can regulate it. Now, exactly how the state regulates it, that's a hard question, but at least we ought to be able to agree the state has the right to regulate, and then let's argue about what the scope of that regulation can be.
So I'm glad that you brought that up, because when I was going through and researching this here, there is that sense, right, where if this is an argument that's been advanced by many people, not the majority, of course, but many people on a prominent platform for a decade or more at this point, why have we not seen any appetite to readdress it? Is it literally just that litigation hasn't found its way up?
Yeah, so if you look at the cases that kind of settled this question, they all are decided within 3 years of Speech Now. And Speech Now was decided 3 months after Citizens United. When Speech Now was decided, Eric Holder, the Attorney General at the time, decided he would not appeal it to the United States Supreme Court because he made a really fundamental mistake. He said, well, the category of speech, independent expenditures, committees that are making independent expenditures, is really small. There's not much money there. So let's not waste our time taking this to the Supreme Court. It doesn't really matter much. What he wasn't recognizing was that once you remove the limit on the size of the contribution to those committees, it would be the obvious loophole through which huge amounts of money could flow. But early in the period, 2010 to 2014, there wasn't really a lot of Super PAC spending. So it wasn't really clear to people that there was an obvious mistake at the core of that opinion. So those decisions never went up. There was no split that ever happened, and it kind of became settled law. And I think settled law against the background where people notice the Supreme Court has increasingly upheld the power of money in all sorts of contexts. So at 50,000 feet, I totally get it. Like, it seems clear the Supreme Court's going to say, no, Maine can't do this because money wins overall. But if you go down from 50,000 feet to about 5,000 feet above the doctrine, and you look at it, and you actually read what they say again and again and again, the doctrine as they articulate it says, yes, the spending can't be restricted, but contributions can be restricted when there's a risk of corruption. And this district court acknowledged there's a risk of that corruption. So the case should have been over at that point from her perspective. But, she made up this brand new theory about why it was constitutionally justified. So all of that is why I think under the existing Supreme Court doctrine, we win. And then there's an even cooler additional argument, which was inspired by maybe my second favorite senator, Josh Hawley from Missouri. So Josh Hawley introduced a bill a couple years ago to overturn Citizens United. Now, so here's a right-wing Republican senator from Missouri overturning Citizens United. And when he did introduce that bill, he gave a speech and he said, every originalist knows that the original meaning of the First Amendment would not have restricted the ability of the Congress to regulate how corporations spend their money. So he's advancing a really important point. This conservative theory of originalism. I clerked for Justice Scalia, so I spent many, many months struggling with the originalist theory of constitutional interpretation. This originalist theory has never been applied to the First Amendment. It's been applied to the Second Amendment. It's been applied to the 14th Amendment. It's been applied to the 13th Amendment. It's been applied everywhere. It's never been applied to the First Amendment. And so the question we're pushing here is, okay, what would an originalist say about the ability of the people of Maine, 600,000 people in the state of Maine? More people voted for this initiative than voted for anything ever in the history of Maine. What's the originalist position on whether 600,000 people in the state of Maine can try to protect their elections from the corrupting influence of money? And the answer is, it's a no-brainer. Absolutely, obviously, Hawley is correct. The First Amendment, as originally interpreted, would never have restricted the people of the state of Maine or the legislature from protecting themselves in their elections. So the second part of the argument that we're pushing and that we hope the Supreme Court considers is, and for you conservatives, Justice Gorsuch, Amy Coney Barrett, at least, maybe Justice Thomas, who has tried to get the court to consider an originalist theory of the First Amendment in the context of New York Times versus Sullivan, at least you originalists ought to look at that and answer the question, what does your principle say here? Do your principles uphold the ability of Maine to regulate or not? And I think if they applied their principles honestly, the honest answer is absolutely the people of Maine have the right to regulate their elections in this way.
And we should talk about the way that the kind of prevailing view of Citizens United has trickled down into states, not just Maine. So, of course, you've been involved in efforts to introduce similar campaign finance reform here in Massachusetts, and that has actually been kind of blocked before it ever gets to the ballot, usually under the justification that, well, if it violates the Declaration of Rights here in Massachusetts, which is our version of that First Amendment and protecting free speech, which we understand is basically protecting the same principles as defined in the U.S. Constitution, as the Supreme Court has defined it. If Citizens United prevents basically these contributions to these super PACs, then they're also allowed in Massachusetts. So the argument there that keeps kind of stopping it from ever getting to a referendum here in Massachusetts is the same principle that you're challenging in this Maine case, right?
So Jennifer, it's actually worse than that. We tried to bring this initiative in Massachusetts, and after we weren't able to do it, I was at a dinner in Maine telling my story, and somebody in Maine said, let's do it in Maine. And I'm really happy they did it in Maine, because Maine's a better state to win with 75% of the vote, because people can see it's Republicans and Democrats and independents, all who agree with this. And if it passed in Massachusetts, you'd say, oh, well, blue Massachusetts wants to stop money. Surprise, surprise. But we've tried to bring it in Massachusetts. The Attorney General, who is now the governor, blocked it. And she said Citizens United blocked it. And we tried to appeal her decision. And then she became governor, and the new Attorney General continued to defend her position that Citizens United blocked it. The Supreme Judicial Court did not say Citizens United blocks it. They said we're not going to...
Said it was moot.
We're not going to decide that question, because before you can decide that question, you've got to gather signatures on the initiative. And once you have the signatures gathered on the initiative, then we will decide whether the initiative is constitutional or not. Okay, That's basically saying, here's $1 million you have to spend in order to appeal the decision of the Attorney General that this is unconstitutional under the Massachusetts Constitution. And my own view is this is an outrageous restriction on the ability of people to bring an initiative. Like if the Attorney General is making a legal judgment, you shouldn't have to force people to waste the money to gather signatures in order to answer the question whether that legal judgment is correct or not. Typically, and indeed the law expressly permits this, and they've done it many, many times, when they've made it to a judgment you disagree with, you appeal it. And there's a process, and you take it up, and eventually the court's supposed to decide the question. They ducked it. They didn't want to have to decide the question. And unfortunately, it creates this terrible precedent that basically says that if you've got an initiative that the Attorney General doesn't like, you got to be willing to spend $1 million at least. That's how much it costs to gather signatures in the state of Massachusetts. You got to spend at least $1 million to gather those signatures, and then you can take a gamble with the court. Well, there's some corporations that can afford to do that, but if you're, an organization, an activist organization, Planned Parenthood type organization, or organization trying to defend renters' rights or something like that, you can't afford that. And so it's a basic way to give the Attorney General the opportunity to block initiatives in the state of, in the Commonwealth of Massachusetts. It makes no sense, but, there was nothing more we could do about it. That was the Supreme Judicial Court.
Right. So one of the things in that decision that was interesting to me was the amount of time and discussion that they spent on the question of, you don't want, I believe they were essentially saying there is a sort of public interest in making sure that you're not wrenching the state's highest court around and making them rule on every potential ballot initiative. So plenty of these would be blocked by the AG's office for a variety of reasons. And so they were essentially saying the best way to balance the efficiency of the court systems with this genuine public interest is to make sure that there is a demonstration of sufficient public support for it. So how did that strike you? Do you want there to be some level of threshold that's higher than 10, but maybe less than the full signature gathering, or do you want them to be kind of ruling on the merits on everything?
Well, look, it's a hard policy question.
No, absolutely.
Who is the Supreme Judicial Court to be making that policy judgment? The legislature and the Constitution of Massachusetts made that policy judgment. They said you needed to gather, I think it's like 10 signatures to get an initiative that then begins the process. They then said we had the Attorney General who could block a certain stage. And then at that point, you get to appeal. Now, the court already has a process for deciding whether an appeal will be decided by one justice or be referred to the whole court. So when we did this originally, we had to fully brief the question to one justice. She looked at it and said it's a hard question. So therefore, we're going to hand it over to the court, and then the court could decide it. But when the court says we're worried about all these crazy initiatives out there, first of all, I don't know who's in the business of ginning up crazy initiatives. I haven't seen that. But okay, if there are those crazy initiatives, then the one justice doesn't have to refer it to the court as a simple way to deal with this problem. But I think the more fundamental thing is, it's just kind of astonishing to me. We live in a democracy where we are so willing to hand over our democracy to judges. This is crazy. The Constitution of Massachusetts gives us the right to bring an initiative to the people to get around the politicians when the politicians are behaving badly. That is our right. And now the Supreme Judicial Court has added on to that right a burden that basically blocks the most vulnerable people bringing an initiative for no good reason and with, in my view, no legal justification at all. This is just judicial activism of its worst kind.
So what does that mean for Massachusetts? So obviously, you folks are going to be pursuing this regardless of who wins at the next level. It will almost certainly be appealed up to the Supreme Court. My understanding is that was sort of part of the thinking in the first place of introducing the Maine referendum to begin with, partially because of what had happened in Massachusetts. So to simplify as much as possible, is there any reason, aside from there is now this additional burden imposed by the Supreme Judicial Court in Massachusetts, not to try and do the ballot initiative again after sufficient time has passed and put down that $1 billion? Is the hope that basically the U.S. Supreme Court will say, go ahead and then there is no reason to block such a thing at the AG's level here in Massachusetts?
Well, certainly, if we take this up to the Supreme Court, and that totally depends on whether the First Circuit agrees with us or not. If the First Circuit agrees with us, we are certainly in the Supreme Court. If they don't, there's a 2% chance we could get an appeal to the Supreme Court. But if they give us a chance to get to the Supreme Court and the Supreme Court rules in the way I think they rule, then I'm sure the Attorney General would not block it in Massachusetts. And so Massachusetts could then consider the same initiative, and I kind of think you wouldn't need an initiative. I think if the Supreme Court agreed, the legislature of Massachusetts would pass a rule that limited super PACs, because this is the one thing, whether you're a Republican, Independent, or Democrat, you agree about. These super PACs are a corruption. But I think that the real focus here then is how do we get that opportunity? And in some sense, this is not really a legal argument, but it's a pretty important practical legal consideration. If the First Circuit does not agree with us, then what's kind of weird about this is to recognize that the most consequential speech in American politics today, super PACs, which are the dominant speech in American politics today, they are the most polarizing and destructive, negative speech in American politics today. That speech has been created without the Supreme Court ever reviewing the question. The Supreme Court has never reviewed whether the Constitution, in fact, mandates this poison inside of our political system. So, one way to think about what the First Circuit could be considering is, okay, even if we think it's a hard question, even if we think it could go either way, maybe we should make it go in a way that at least gives the court a chance to finally address it and let the court take responsibility for this being the rule. And I think if we did that, the Supreme Court, many people think that the Supreme Court is just a bunch of politicians. I don't believe that. I clerked there. I clerked there as a liberal for Justice Scalia. I saw, not in every case, but I saw in the vast majority of cases them struggling to do the right thing according to their own philosophy. And I kind of think that's who they are today. And I think that if you get to the Supreme Court, even if they think, boy, is this going to hurt the Republican Party because we're all Republicans, they would have to conclude, no, because super PACs don't benefit just the Republican Party. They benefit the Democratic. If you take Elon Musk out of the 2024 cycle, Democrats had more money in super PACs in that election cycle. And that was true also in 2020 and 2022. So I think that there's no partisan reason to like super PACs anymore. And I think this Supreme Court would look at the world they're in right now, where money in politics, Pew reports, is the number one issue Americans care about. They identify this as the number one problem we have to solve if we're going to solve anything else. And they would look at the kind of very different kind of corruption that's kind of in plain sight right now with the president and everything else going on, and find it very hard to uphold a rule that would continue to fuel that corruption, and find it very easy to say, look, under our principles, we're not changing our principles. We're applying our principles to a set of facts we've never considered. Under our principles, Maine wins. I think that all the cards are on our side, both political, institutional, and legal, and that's why I think this is a shot we got to take.
Yeah, I think just kind of ending on that point that you raised there, the Pew Research, looking at it, asked respondents who basically has too much influence when it comes to the decisions that members of Congress make. And as might not shock you, very few people said it was the people in their districts who had too much power over what Congress people do with their time. But then almost immediately, once you get into large employers, 60 and 63%, so that's Republican and Democrats, saying that's too much power. Lobbyists and special interest groups, Republicans were actually more likely to say that they had too much power. That was 78% of them to Democrats 72. And then up at the very top was the people who donated a lot of money to their political campaigns. That was 83% of Republicans and 80% of Democrats. So I think kind of with that in mind, the only question that I think we have time for today to cap it off is there any reason to think that the current Supreme Court has an appetite to take this issue on right now? It's 2% chance they'd have to agree to grant cert if, of course, you folks lost and appealed it. So do you actually think they want to settle this?
I think if they're forced to take it, which they would be if the First Circuit went with us, yes, they would decide to take it on and decide in our favor. James Madison in Federalist 52 promised that we would have a republic, quote, dependent on the people alone. And by the people, he went on in Federalist 57 to say, he meant, quote, not the rich more than the poor. Well, the poll you just revealed shows that the people believe it's not the people alone upon whom Congress is dependent. Congress is dependent on their funders. Like, they only get to be in Congress if they've pleased their funders first. So I think we have totally corrupted the idea of representative democracy that our framers gave us, a democracy dependent on the people alone. And I think the court has no good reason not to try to take this one step. Not to overturn Citizens United. We're not asking them to overturn Citizens United, not to overturn Buckley, but to apply those principles consistently. And if they do, they will agree that even if the spending is independent, there's a good reason for Maine to be worried that the contributions are not, and therefore a good reason for Maine to limit the size of those contributions to minimize the chance they are the product of corruption.
All right, well, that's all the time we have. Professor Larry Lessig, thank you so much for joining me today.
Thanks for having me, Jennifer.
Thanks again to Professor Larry Lessig for joining me on the Codcast. Thank you so much for listening. I'm Jennifer Smith. Our producer is Charlie Cazella, and our theme music is also by Charlie Cazella. Leave us a rating and review wherever you're hearing this now if you want to help other people find us, and email codcast@commonwealthbeacon.org if you ever want to get in touch directly. We'll be back in your ears next week.